So, how does one determine the validity of a regulation under the APA? The judicial branch in California, obviously, as the interpreter of the laws, has the ultimate say over the validity of regulations that are adopted by the executive branch of state governments, agencies, departments, boards, and commissions. So, how do the courts in this state consider the validity of regulations that have been adopted pursuant to the rules in the government code found in the Administrative Procedure Act? Well, there's a number of court decisions that give us some amount of guidance in this regard. In the California Appellate Court decision, San Diego Nursery Company versus the Agricultural Labor Relations Board, that was issued in 1979, the Court of Appeals said, as an initial matter, in assessing the validity of an administrative rule, the court's task is to inquire into the legality of the challenged regulation, not its wisdom. In reviewing the legality of a regulation or policy adopted pursuant to a delegation of legislative power, the courts are limited to determining whether it is within the scope of authority conferred on the agency and is reasonably necessary to effectuate the purpose of the statute. The California Supreme Court in 2019, in the case of In Re McGee, said the task of a court considering the validity of a regulation promulgated by an agency is to decide whether the agency reasonably interpreted its legislative mandate. The Court of Appeals in 1998 in Terhune versus Superior Court also said an administrative agency has no discretion to promulgate a regulation that is inconsistent with the governing statutes. And in Coastside Fishing Club versus the California Fish and Game Commission, a 2013 California Court of Appeals case, the appellate court said, in challenging the validity of a regulation, an interested person may pursue either the APA's pre-adoption administrative remedy, post-adoption judicial remedy, or both of them. In greater detail, the courts have said a regulation as defined under the APA and falling within the relevant two-pronged test is not valid if it does not adhere to APA requirements for its adoption. To comply with the APA's requirements for adoption of a regulation, an agency must give the public notice of its proposed regulatory action, issue a complete text of the proposed regulation with a statement of the reasons for it, give interested parties an opportunity to comment on the proposed regulation, respond in writing to public comments, and forward a file of all materials on which the agency relied in the regulatory process. Any regulation that substantially fails to comply with these requirements may be judicially declared invalid. And this was set forth in the case of Poet LLC versus the State Air Resources Board, a 2013 California Court of Appeal decision in which the California Supreme Court denied review. I also look at Raybuck versus Superior Court, another 2013 California Court of Appeal decision, which the Cal Supreme Court also denied review. And they said a regulation may be declared invalid if, one, the agency's determination that the regulation is reasonably necessary to effectuate the purpose of the statute, court decision, or other provision of law that is being implemented, interpreted, or made specific by the regulation is not supported by substantial evidence, or two, the agency declaration pursuant to a statute governing notice of proposed adoption is in conflict with substantial evidence in the record. Another Court of Appeal decision in 2010, the California School Boards Association versus State Board of Education, another decision that was denied review by the California Supreme Court. The appellate court explained an agency does not have discretion to promulgate regulations that are inconsistent with the governing statute, alter or amend the statute, or enlarge its scope. Where regulations are void because of inconsistency or conflict with the governing statute, a court has a duty to strike them down. In addition, the Court of Appeal in 2006 in Teichert Construction versus California Occupational Safety and Health Appeals Board said, in considering the vagueness challenge to an administrative regulation, courts do not view the regulation in the abstract, but rather they consider whether the regulation is vague when applied to the complaining party's conduct in light of the specific facts of the particular case. If it can be given a reasonable and practical construction that is consistent with probable legislative intent and encompasses the conduct of the complaining party, then the regulation is valid. While vagueness challenges to a statute arise most commonly in the criminal context, the prohibition extends vagueness to administrative regulations as well. Another decision by the Court of Appeals in 2011, California Association of Medical Product Suppliers versus Maxwell Jolly, the appellate court said it would be inappropriate for the Court of Appeal to invalidate a regulation based on lack of clarity under the APA, since that issue is for the OAL rather than the Court of Appeal. The APA provision defining clarity does not provide a legal basis for courts to declare a regulation invalid for lack of clarity. And finally, turning again to the California Association of Medical Product Suppliers versus Maxwell Jolly in 2011, the appellate court said, regarding the required economic analysis, a regulation is not necessarily invalid under the APA, even if it has a significant adverse economic impact on business. And finally, the California Supreme Court said in Western States Petroleum Association versus the Board of Equalization, a 2013 case, in addition, under the APA, a regulation will not be invalidated simply because of disagreement over the strict accuracy of costs estimated on which the agency relied to support its initial determination. So said our state's high court.